Hi, good morning. I'm Andrew Smith. I'm the Director of the Bureau of Consumer Protection at the Federal Trade Commission. So my standard disclaimer, I speak only for myself, not for the Commission or for any individual commissioner. That disclaimer is especially heartfelt today because we have 5 really brand new commissioners at the Federal Trade Commission. So I'm here to talk with you about privacy and data security. And for a lot of these commissioners, so we have all have joined within the last 6 months. That's unprecedented at the Commission. Since the Commission originally opened its doors in 1914, that was the last time that we had 5 new commissioners. And these commissioners, as is frequently the case at the FTC, because we have a dual mission, antitrust and consumer protection, these commissioners are, at least 4 out of the 5, have significant antitrust experience. And although they're not entirely new to consumer protection, that hasn't been the area where they've been practicing for most of their career. So they come to us to a large extent without any priors on issues like privacy and data security. So it's an interesting time at the Commission as the commissioners and the Commission find their way on these issues. So I'm new to the Commission too. I joined in May of 2018 after wandering in the wilderness of private practice for 10 or 15 years as a partner at 2 different law firms here in DC. But I am more or less a privacy person. I was last at the Federal Trade Commission from 2001 to 2005, where I was in charge of the Fair Credit Reporting Act program. And one of my last official acts at the FTC was drafting testimony for Chairman Debbie Majoris in support of national data security breach notification standards. So that's the cue for all of you data security people to laugh at me. Because as you know, in 2005 it was must-have legislation. 47 states, are going to enact their own data security breach notification laws. We need a uniform national standard. And in fact, we never got a uniform national standard. We still don't have one. 47, 48, 49 states did enact their own laws. And we figured out how to cope with it. But we may be in a similar spot now with respect to privacy, given the California legislation. So there's now, again, starting to be noise on the Hill about the need for a uniform national standard with respect to privacy. From the FTC's perspective, we will enforce the laws that Congress gives us to enforce. The commissioners, though, and the Commission may have a position on the wisdom of a national privacy standard. So let's talk a bit about data security. We, for better or worse, have been the data security agency since the early 2000s when I was drafting that testimony. We've brought more than 60 data security cases over that period of time. We have more in the pipeline. One thing to keep an eye on for those of you who are data security people is our Glba safeguards rule. So this is the rule that sets up standards for the security of personal financial information. Glba safeguards rule, we initially promulgated it in 2003, and interestingly enough, I was at the Commission at that time, and I worked on it at that time, although not in charge of it. There were a lot of challenges for us at the FTC making those data security rules, one of which is that we are not a supervisory agency. So unlike the banking agencies who also were charged with making rules, the banking agencies know exactly who they regulate. They have, those 4,500 national banks and those, non-member banks and member banks. So the Fed, the FDIC, OCC know exactly who they're regulating, and they're in their offices, in many cases, 365 days a year. So very different agency at the FTC as a law enforcement agency. So we needed a standard that was enforceable, but it couldn't be too prescriptive because data security is constantly changing. So if we said you must have 128-bit encryption, then that would quickly be surpassed by 256-bit encryption or 512-bit encryption. So we couldn't lay out those kinds of standards. So what did we do? We made a rule that was fairly basic, but it was process-based. We talked about assessing the risks to data in your organization and developing a written plan to address those risks, and appointing someone to oversee the plan and ensuring that your vendors are participating in the plan and that they know what the plan is and that they're not working at cross purposes with the plan. So at the time, it was a new kind of rule. Since then, data security rules have largely followed that pattern, and a lot of other financial services rules as well, like all of the rules that came out of the Fair Credit Reporting Act reauthorization in 2003 are those kinds of risk-based rules. But it was 2003. Data security has advanced a tremendous amount in the last 15 years. I mean, in 2003, it was really just nascent at that point in time. So in that last 15 years, some state legislators and some state regulators have chosen to adopt additional standards. And one of my concerns is that the GLBA safeguards rule keep up. So if states want to enact their own laws, fine. Again, that's not my department at the FTC. I care about protection of consumers and enforcement of federal laws. But if there are some states who are casting around for a standard that they believe to be, that they wish were more fulsome or more detailed or would give more guidance to the kinds of businesses, the kinds of non-bank businesses that the FTC, non-bank financial institutions that the FTC regulates, well then we want to be able to give them that standard. So the GLBA safeguards rule is under routine regulatory review. We issued a request for information a while ago. And I'm not sure exactly when, a year or more ago. And we are now preparing a notice of proposed rulemaking. There are certain aspects of the rule, of the GLBA privacy and data security rule, that need to be revised just for changes in the law. So we're preparing a notice of proposed rulemaking. And if for folks who care about the safeguards rule and the security of financial data, then you should pay attention to our and ideally comment on whatever it is that the Commission proposes. So let's talk a little bit about privacy now, and in specific, given that it is October, I am interested in the GDPR and the renewal of the EU-US Privacy Shield framework. So every year in October, the Privacy Shield framework needs to be renewed by the European Commission. And folks, you're probably familiar with the GDPR generally, and the EU rules say that people in the EU cannot transfer personal data to outside of the EU to jurisdictions that are deemed to be inadequate. Well, the US is one such inadequate jurisdiction, doesn't offer adequate protections to personal information. Don't feel too bad, though. Most jurisdictions are not adequate. The jurisdictions that are adequate, I think Isle of Man, Isle of Jersey, Argentina, so there are a couple, but for the most part, not adequate. So what the Department of Commerce and the European Commission have done is agreed on this framework of voluntary principles that companies can adhere to, and if they do, if they subscribe to this Privacy Shield framework, then they can transfer data out of the EU to the United States. It's an extremely important arrangement that Commerce and the EC have agreed to, and it supports hundreds of billions of dollars in transatlantic data flows. And we at the FTC have an important role to play because we are the ones who are responsible for enforcing that Privacy Shield framework against companies that fail to adhere to it. So the renewal of that Privacy Shield framework is a top priority. for the Federal Trade Commission and for me as the director of the Bureau of Consumer Protection. Now, there are, of course, in Europe, and talking about the Privacy Shield framework, a lot of this grows out of concerns of government intrusion into personal privacy. That's something where the FTC, we don't have a dog in that fight. What we care about is commercial intrusion into privacy. Companies collecting data they say they're not going to collect, sharing data they say they're not going to share, using data in ways that they say they're not going to use it. So that's where we live. Is in this notion of commercial freedom from commercial intrusion. So our chairman was in Brussels last week in support of the Privacy Shield renewal. Commissioner Noah Phillips, is in Brussels this week. We're hopeful for a successful conclusion to the Privacy Shield process. I think sometime within the next month, which would mean a renewal of the Privacy Shield framework. In support of that, of the U.S. argument for renewal, we at the FTC have brought 5 actions to enforce the Privacy Shield framework in the last year, 4 within the last month or 2. And as announced by the chairman last week in Brussels, we're investigating additional targets to monitor them for compliance as well. In addition, the chairman announced in Brussels a case that we brought under the Fair Credit Reporting Act against a company called RealPage, which is a tenant screening company. And what was happening there was that RealPage RealPage would return reports to landlords to screen tenants to make sure that there are not safety risks and the like. And RealPage, we allege, was including in those reports information about other people other than the subject of the report. So criminal records, sex offender records, and the like from people other than the subject. So what happened? This resulted in people losing apartments, which matters a lot, particularly in this economy where apartment rental and housing has become so tight. Why do I mention it to you, though? I mention it to you because the EU is quite concerned about algorithmic decision-making. And this is essentially the practice in which RealPage was engaged. It would score these individuals as risks for whatever it is the landlord is trying to predict. Is he trying to predict that this person is a safety risk? Is he trying to predict that this person is a payment risk? What is it? So we have this law, the Fair Credit Reporting Act, which is enacted in 1970, right? I mean, 30 or 40 years before anyone really cared about privacy in Europe, or at least the EU Privacy Directive. And we've been steadily enforcing it and building a body of law under it. And the Europeans, when they heard about this Fair Credit Reporting Act action against RealPage, lit up, I'm told, and that they were really interested in the US leadership on these types of quite esoteric privacy issues, but that really hit consumers where they live. And that make a big difference in the lives of individual consumers. And there doesn't seem to be an awareness of the fact that the US has had this leadership role for really generations at this point. To close up, I want to remind you that the FTC has announced a series of hearings. It's entitled Consumer Protection and Competition in the 21st Century, hearings over the next couple of months. We have hearings planned on big data, artificial intelligence, data security. Those hearings have been announced. And what we're talking about there, at least with respect to big data and artificial intelligence, is not only the effects on consumers and the ramifications for consumer protection, but also on competition. And how can these tools either enhance competition or hinder competition and entrench incumbents and close out new entrants into the marketplace? All things the Commission and the commissioners are very interested in. We have hearings on privacy planned not yet announced, I don't believe. Hopefully in the next couple of weeks there will be dates and topics and requests for information released to the public. But even without that, we have done plenty of work on privacy issues, and including just in the last couple of days, we published what we call a staff perspective, sort of a readout, a report from our informational injury workshop from last year, which presents issues where we studied issues beyond the types of injury to consumers, beyond just the pecuniary financial injury that might be visited upon them by privacy violations. So, with that, I will leave you with the thought that the FTC and the commissioners have given us no indication that they don't care about privacy and data security, and that it will continue to be a high priority for the Federal Trade Commission. Thank you.